So before we dive in, Robin, can we just review for us the sequence of order of events here?
Okay, we got a little off track, I think, because Mr. Davis was going to do an opening statement, but that sort of morphed into his testimony. So I think what we should do at this point is let Mr. McGuire cross-examine Mr. Davis, and then bring Mr. Glines back up and let both parties ask him whatever questions they want, and then we can jump back in. How many witnesses do you have?
Just one.
Okay, and then we'll do your witness, that cross-examination, and then turn to the applicant.
Okay. That's
Is
fine.
that good with everybody, Mr. McGuire?
Yes,
Okay, all right. Do you have any questions for Mr. Davis?
I do.
Okay.
How does this normally work? Do we both stand at the podium and look each other eye to eye? Is that how it works?
We don't do this normal.
This is not
Yeah,
a normal
this is not
situation.
normal. But I think they both need to talk in the mic, don't they, Maggie? I mean, Ms. Burleson?
Will this work?
I promise I'm not a hostile witness.
May I proceed? You understand today's review is a non-discretionary technical review over the UDO,
No, I don't. No, it's a quasi-judicial hearing concerning the UDO.
but it relates to the technical requirements of meeting the UDO.
It relates to discretionary requirements as well that are part of the UDO.
And questions about views or whatever are not part of what the UDO deals with in this situation.
That's not true. It does deal with views.
And you've been in your condo how long?
For approximately 6 months, your office did the closing for me. So.
And as a land use attorney, you understand that no view is guaranteed in an urban environment?
No particular view is guaranteed, but views are guaranteed as part of the UDO.
Where in the UDO is a view guaranteed?
Well, it's guaranteed in the provision we've been talking about, for one, dealing with floor plate area.
Does it say guarantee a view, or does it says view as a consideration?
It says to preserve views.
Okay, so there's no guarantee.
Not for any particular view, no.
Right. And you understand that Mr. Fraga's Haywood Park Hotel had its views blocks when your condominium project was put in, right?
Actually, I understand he didn't own it at that time.
Well, but whoever did own it, that's part of being in a downtown environment. Someone may build a building that blocks your views. That happened to my office, it happened to Mr. Haywood, the Haywood Park Hotel, and it's now, you think, happening at your
I
business.
understand Mr. Fraga bought the Haywood Park Hotel after that happened.
Okay. And were you in any way, like Mr. Glines, involved in writing and revising the UDO?
I was not. I wasn't living here.
So anything you know about its meaning would be based upon what you think should happen in this particular case?
No, that's not true. I've read all of the minutes from the City Council pertaining to the adoption of the UDO. I've read the UDO in great detail, so no, that's not true.
So you're well read on it?
And I also have an expert witness who's going to
Okay.
testify.
And you're aware that Mr. Fraga made substantial changes to this design to accommodate views of some of the residents of 21 Battery Park?
I was at a meeting in October of 2013 when Mr. Fraga presented essentially the same project that he's presenting today. And whether there were any changes made before that presentation to the neighborhood as a neighborhood meeting, I don't know.
And if there were a neighborhood meeting, which I think there was, months before you came to town, obviously you know nothing about that neighborhood meeting.
No, the neighborhood meeting was October 2013, and I was present for that,
And at that point, Mr. Fraga got input from the various residents?
and ignored it.
He ignored your input?
No, he ignored the input from several people at that meeting, including several residents of the west side of 21 Battery Park, who complained about their lack of light in their views.
Okay. Now, you say that this project may be under 21,000 square feet, so that B would apply rather than C?
Under 20,000.
Yes. But you don't have any evidence as to whether it's just under or just over, do you?
I have the dimensions that were listed on the plans provided to the City Council.
Before they were revised?
I have the revised plans.
Okay. And do you have any evidence to support under the revised plans where it shows it's under 20,000 square feet?
Well, I have the survey of the parcels. I mean, I don't know how you can get better than that.
And the revised partial shows it's hot more than 20,000 square feet, correct?
I haven't seen a revised survey.
Okay. Now, when you talk about open space, all of your comments before council up to now had to do with the on top of the Grove Arcade, correct?
No. I mean,
Did you talk about whether there was open space on any other side of the project?
well, there are buildings on every side of the project.
Right. Can you not have open space between buildings?
You can have some open space between buildings, yes.
And in fact, the deep, dark hole that you're talking about, it's 50 feet from your project over to the building we're talking about, correct?
That is correct, but that is parking space which cannot be used as open space under the UDO.
Does give you air and light.
But it's not open space.
Okay, so we want to get technical, and that's fair enough.
That's what we're here for.
Yeah, absolutely, and we'll get technical, but in terms of your being in a deep, dark hole, it's 50 feet over that hole.
I've seen the shadow studies that were referred to but not shown to anybody, and that deep, dark hole is deep and dark all but 2 hours a day.
Now,
No, with the project.
you've seen that the shadow study shows that the shadow impact requirements have been complied with in this case.
Assuming that's a valid study, it shows that for the public plaza, which is, I consider the sidewalk along the Grove Arcade a public plaza, that it only is impacted about an hour a day.
So you're not arguing the shadow impact, or you have no evidence relating to that today?
I don't have any evidence to refute the drawing that I've seen that Mr. Glines apparently reviewed very
Yes.
briefly.
Okay, so that's not an issue for decision today, shadow impact?
It's an issue if your client brings it up.
Okay, but not from your viewpoint?
I didn't bring it up.
Okay. Now, there is open space. Well, first of all, the definition of open space. The definition in the UDO gives examples, correct?
It gives a definition plus examples.
And the examples are, it says the examples are not limited to those examples. The open space is not limited to those examples, correct?
That it says may include but is not limited to, correct?
So you would interpret that as someone who wrote that knew there might be other examples of open space.
Well, except that the open space is further limited by the definitions and the language in the open space standards.
And you understand generally open space standards may vary from one use to another?
They do, yes.
Okay. And there's nothing in the open space definition in any way that excludes including the top of the Grove Arcade.
Well, let's be specific. In 7-2-5, there's nothing that even remotely resembles the top of the Grove Arcade. But it doesn't exclude it explicitly, but in 7-11-4, it does.
Okay. Now, if you had, say, the original tower on the Grove Park Inn that was intended by Mr. Grove, you know who Mr. Grove is?
I do.
And you've seen...
I haven't met Mr. Grove.
Right. Of course, he's been gone for decades, but you've seen the design.
I have.
that he had
It's
intended.
right on the street corner.
And if that had been built, so the Grove Arcade, how many more was he contemplating, 8 or 10, Mr. Grove?
I don't know.
That would certainly affect the light and air on the other side of the street.
But it's a skinny tower.
It's a skinny tower, but the point is that if you had...
To a certain extent, yes.
If you had a skinny or a fat or any kind of tower over there that took up open space, it would keep air and sunlight from coming down to where the current building is and where your building is.
But it would probably comply with the UDO because it's a very small percentage of the lot.
And is there any definition here about how much open space there has to be? That's something that the staff is to fairly interpret?
The term is substantial, and I think that's for the city council to interpret.
That's correct. But there's no set percentage or amount of air or otherwise?
No, it just says substantial, permanent, public, or private.
Okay. Now, let me ask you a couple of things just about your space, if I may. And if I think this will work out okay, if I can show you these photographs so that folks can see them.
I might have to adjust this. There we go.
Okay. That shows a little bit of a shadow, but does X mark the spot being your...
Make sure you speak in the mic so that we can get the recording. Thanks.
does this show X where your condo is?
Yes.
Okay. And does this also show that? That is your condo on the other side of those trees?
It's obscured by a tree, but yes.
Okay. And you're not complaining about the tree cutting out your air and light, are you?
Well, no, in the wintertime, I have a perfect view of the Grove Arcade.
And is that another photo shows your condominium behind those trees?
Yes.
Okay. And is this photograph show X where the side of your condominium is?
We're in the back of the building or the north side of the building, yes.
Right. And what does that area look over to? The wall?
That looks over to the wall of the Haywood parking garage.
Okay. And is this a photograph showing X where about the level that ladder goes up to where your condo is?
That's my office window to
Yes.
the right of the X, yes.
And is this a fair view? It's actually taken from that ladder of your view from your condo?
With the leaves on the trees, yes.
Okay. And is this the view from your alley window? That is, you look over at a wall?
It's better than that, I think.
Okay. But basically, it looks over to the
It
wall?
does look at a wall.
Okay. Now, in considering open space, it's also legitimate, is it not, to consider space on sidewalks?
Sidewalks that are substantially larger than the requirements.
And that would be true of the sidewalk in front of Grove Arcade, correct?
I don't know.
Well, now, you called it a public plaza.
Well, I mean, it's one that I think is wide at points, is not wide at other points.
Well, how could it be a public plaza but not big enough to be a walkway for purposes of air and space?
Well, if that is, that's not substantial.
Okay, you think you're being consistent on this, Mr. Davis?
Well, of course I am, yeah.
You want to say it's a plaza, but it's not open space?
I don't know the requirements for sidewalks,
Okay.
okay?
But it's open space, and the open space definition specifically includes walkways.
That it does.
So it would include sidewalks.
It could include sidewalks. If you look at 7-11-4, however, it restricts that to sidewalks that are substantially larger than the requirements.
Ones that might even be called a plaza.
Correct.
Okay. And you would have to consider not only the roof of the Grove Arcade, but the open space over what you call a plaza between the Grove Arcade and this projected building.
I don't understand the question.
Open space, whether or not it includes above the Grove Arcade, would certainly include the space on the larger than usual, you call it a public plaza area between the Grove Arcade and where this building will be.
If those sidewalks are wider than the requirements, substantially wider than requirements, yes.
And do you dispute that they're substantially wider with the tables?
I don't know. I didn't hear Mr. Glines talk about the requirements, so I don't know.
So you don't take any position on that?
I don't.
And there's also open space on the north end going across Battery Park, correct? There's sidewalks over there on both sides of that street.
There's a sidewalk on the east side of I'm sorry. Sidewalk, you're talking the north end of what?
Yes, of the building.
Then-
Battery Park Avenue.
The north end of the building would be not on Battery Park. That's the south end of the building.
Could be across looking over to the restaurants that have, like next to the Grove Arcade, expanded sidewalks.
There are sidewalks over there. I don't know how wide they are.
But you know there's dining out on them, correct?
There is, yeah.
And you can walk in between the dining area and the restaurant, so it's wider than normal sidewalk.
Well,
correct?
there's a bump out for dining.
Okay, and that makes it, would you call that a plaza?
No,
Okay, but certainly open space,
it's a sidewalk.
which is open space under the walkway example of open space.
Only if it's substantially larger than the requirements.
And you don't know, you have no idea whether any of these sidewalks where they have al fresco dining and so forth are substantially larger.
I don't.
Okay. You would prefer Mr. Grimes on that?
I didn't hear him testify about that.
You did hear him testify, though, that he considered open space to be those sidewalks.
I did. I
Okay, so
did.
he did cover that he thought those sidewalks were open space.
And he said he didn't think it was a public plaza either.
Okay. And one other question about the Grove Arcade top, you're aware that there's an agreement in place with the Historic Preservation Society that allows no further building above where it is now?
I have reviewed an easement,
Yes.
if that's what you're talking
And that
about.
easement says no further building up above the top of the Grove Arcade.
Unless it was changed. I mean, the easement restricts that, but easements can be changed.
But it restricts it permanently, correct?
Permanent easements can be changed.
Okay. But what we're talking about today is what open space is there today, correct?
No, we're talking permanent open space. That's the term used in the UDO.
And there's, how much open space is there between where this building will be and your balcony?
I haven't measured that. And that's not open space under the definition in the UDO because it's parking.
Is it all parking?
Yes. There's a ramp, which is for vehicular access, which is also excluded as open space.
So you want to exclude some air and light because you think technically under the UDO, there's not enough open space on the other three sides.
Now, I'm not trying to exclude anything. The UDO excludes it. So,
That's all.
I can't redirect myself, so I'll just take a seat.
Okay, just hold on. Did council have any more questions for Mr. Davis? Okay, now, what we said next was Mr. Glines to come back and give Mr. Davis an opportunity to question him, and then Mr. McGuire.
Give me 1 minute. I need to get my executive meeting.
Yeah, just while he's doing that, ask that, make sure that what has been admitted by Mr. Glines in terms of his report is actually in evidence.
Yeah, that's fine, or that's fine with me, as long as Mr. Davis is paying attention there. Okay, I think he said he wanted to make sure that what Mr. Glines testified to was actually in the record and evidence.
Yes, ma'am.
Okay.
His actual testimony or the report?
I think he's talking about, the report is in, I think he's talking about the actual papers that he was showing.
Yes, his exhibits.
Yeah.
Can we somehow mark those and make them exhibits? I mean, I just, or at least give it a number, please.
Mr. McGuire, what were you going to ask him?
My suggestion is that be in one exhibit, because he went through it as one exhibit, and that be admitted, I'd request that be admitted as part of the record.
Okay, and do you have any objection to that, Mr. Davis?
No, I do not.
Okay, so, Mr. Glines, do you have a copy of that you can make available?
Can I do it after, in case I need to refer to something?
That'll be fine. And we'll get a copy, make sure you get a copy, Mr. Davis. I do think everything you referred to is either in the staff report or the application. Is that correct? Mr. Glines? Okay.
And we'll have electronic copies that were sent to us.
Yes, and I think the point was anything he talked about, we've already got. So, or you've already got.
Ready?
Everybody ready? Okay.
Here we go.
Okay, Mr. Glines, how long have you been with the city of Asheville as a planner?
I've been with the city of Asheville since 1997,
Okay.
and I was a park planner when coming in.
Okay, how long have you been an urban planner?
Since, I believe the date was 2001.
Okay, roughly 13 years. In that entire 13 years, have you ever approved any open space determination based upon the space above a building?
I'm trying to remember if we've had a rooftop deck in the past.
Or have you?
Yeah. We've had rooftop decks approved in the past, but in the downtown area, we don't require open space. So they didn't have to meet any standard besides that they were on a site plan and approved.
Okay, well, anywhere in the city of Asheville, have you ever approved open space which includes area above a building?
I think of some other projects. I'm thinking of the Pioneer Building on Broadway. I can't remember all the particulars of that plan, but they do have a rooftop open area on the top, and they also have some space in front, but I can't attest to which combination of space on top and which space in front constitute the open space.
In other words, you don't know.
I can think of examples with buildings developed in the city of Asheville who have rooftop spaces, whether or not they had to meet a technical standard to be justified as open space, I can't say right now.
Well, you understand that when a developer counts something as open space, they essentially dedicate it that way, right?
I don't know that, yes, okay.
Well, I mean, it's part of their project from there on. They have to preserve their open space that they dedicate as part of their approval process, right?
If it's, yes.
And so you would know if you had approved a certain amount of open space that was space above a building.
Of the building to meet the open space standard. I
Yes.
can't recall everything that we reviewed over those 2 years.
Okay. Well, and did you receive a document request from me for any documents wherein you've approved open space as a space above a building?
We have seen that. We haven't had time to respond to it. It came last week late.
It came last week, but you haven't found anything yet.
I haven't had a chance to look, to be honest with you, to start.
Okay, well, let's go back to the types of things that you said count as open space for this project. And before we do that, what do you mean by substantial?
A good amount. Substantial
A
is a good amount.
A good amount. Are we talking blocks worth? Are we talking thousands of square feet?
I think that in this case, studying this site, that we are probably in the thousands of square feet.
If you count the tops of buildings, right?
And you count the ground as well.
Well, let's go into what you said counted here. But first, let me make sure that we're looking at the definitions. It might be easier to go back and do this.
I'll need to swap this out.
Let's look at the open space standards, and let's start with that. It says the classes of land enumerated in the subparagraphs below may be utilized to meet the requirements of this section. You understand that's what your UDO at section 7-11-4D says, right?
Right, in section 11, it says that.
Right. And then it goes on to say, in no case shall the following land be used for open space: land occupied by streets, drives, parking areas, required landscape buffers, or structures other than recreational structures.
Okay, I see that written there, sure.
And is that something that you're familiar with in your practice?
We could find that in 711-4 of the open space standards of the UDO, correct?
And you did not review this when it came to determining what substantial open space was for the proposed FERC project?
We have considered this and reviewed it.
Well, and you have a list of bullets in your staff report that you went through with the City Council a few moments ago, and the first one was substantial sidewalk areas surround this property directly adjacent to the site and across the street. Now, are these land used for public sidewalks significantly in excess of the standard sidewalk requirements?
I believe that they are.
Which ones?
I believe that the downtown standard for sidewalks is 10 feet for new construction, and proposed and new sidewalks in all cases will be greater than 10 feet. So, I believe we could, if we had a scale plan, we could study the exact sidewalk in front of the building as proposed. It'll be at least 11 feet. So that is 1 foot substantial, is 10% more than requirement.
11 feet for which one you're talking about?
For the Cambria project proposed.
The one that's required for the project itself.
Yeah.
And that's not a public sidewalk, is it?
Oh, yeah.
Well, it's public in the sense that
Completely public.
the public can use it, but the developer is being required to provide it as part of the project approval, correct?
Correct, but it's a public sidewalk. And then on Battery Park Avenue, again, adjacent to the building, the sidewalks there are quite substantial. They're at least 15 feet today and will be when the site is developed and approved or developed and built. The final, so a 5 feet more in a downtown area, 5 feet over 10 feet. We're thrilled. I can tell you that as a planner, we're thrilled to have 15-foot sidewalks anywhere in downtown area, and that's substantial. In the Grove Arcade, if I can continue.
Let me ask you a question about that. Are those sidewalks?
Can you finish his answer?
Well, I was going to ask him a question about what he just said, and then he can continue.
Let him finish his answer.
I'll be brief, and I apologize. Just in front of the Grove Arcade, that sidewalk is quite substantial. I took a tape measure out there, and I did measure it, and it's 18 feet is the standard width in front of the Grove Arcade, 18 feet. And that includes the dining spaces and the wide aisle and the street trees and the benches, all in that terrific public space out front. And that's not counting those dining spaces that have to do with Carmel's and some of the other spaces that have bigger bulb outs on the corner or halfway up the block. There's greater spaces developed for those, for public amenity space. And that was beautiful improvements done when the Grove Arcade was improved. As I said before, it wasn't dedicated as a plaza, but it is valuable open space.
You would consider it a plaza, wouldn't you?
No, I don't consider it a plaza because the Grove Arcade is privately managed. It's not something that, from a public standpoint, we have control over. The Grove Arcade Foundation does.
Well, we're going to leave that issue aside, but the next bullet you had was the combination of building step-backs, which are required under the UDO for this project. That is land occupied by structures other than recreational structures, correct?
I think they're recreational structures. I think they're recreational uses.
A hotel is a recreational structure?
I think the bar and the restaurant are, and I think the outdoor plaza is for the enjoyment of patrons who would visit the hotel and would stay there.
Is that what you would consider recreation, public recreation in this city?
It's private recreation. It's
No, I
for
admit I
private purpose.
recreate some in that capacity myself, but I mean, that's not what the UDO considers open space, is it?
In this consideration, I don't think it's limited. It's limiting that. I think that can be counted.
Even though 7-11-4 says, in no case shall structures other than recreation structures be considered.
You're on top of a building. Is there any other use on top of that building? It's for recreation purposes on top. Could you not have a rooftop deck or other facility? What's a balcony? It's part of a balcony is part of a structure.
I know you want to argue your point.
No, I think it's...
I mean, you were meeting with Mr. McGuire before you came on for cross-examination. Was he giving you pointers about your testimony?
No, sir, he wasn't.
Okay, what were you discussing with Mr. McGuire?
Ms. Daniel wanted to talk about, in an urban setting, and I shouldn't talk about another witness who might be a potential witness, but in an urban setting, it's common to use rooftop decks as open space, to meet open space requirements if you have them to meet.
Which is prohibited by 7-11-4, correct?
I don't agree with that. I don't agree with the way you're interpreting that up there.
I mean, I'm just reading words.
Let's move along. We've
Well, let
asked
me-
and answered
next bullet
about
point.
10 times.
Well, next bullet point, the Grove Arcade is height protected. That doesn't comply with 7-11-4, the top of Grove Arcade.
But the definition, the basic definition, starting in the beginning of the UDO, 725, open space means an area that is intended to provide air and light. What does that do on that roof? Because it's not going to be built upon, it will always provide a western view that provides air and light to everybody that's east of it.
Except for people east of the Fraga building, right?
Not everybody.
Well, but looking at 7-11-4, you would agree that it prohibits the use of structures as open space, correct?
But if you have a rooftop deck, is that not designed as a recreational space? You don't think it is?
Is there a rooftop deck on the Grove Arcade?
I don't think so.
Okay. Now, on to the next one is the roof of the podium height of the proposed Cambria Hotel building at the 3rd and 4th levels provides a restaurant. You say that serves as open space.
I do.
That's land occupied by structures other than recreational structures, correct?
I would say that's designed to be a recreational space.
Is that not a commercial space for the benefit of the patrons of the hotel and the people who frequent the restaurant for the profit of FERC?
I don't think that's a restriction on the type of open space because it already says it's private or public. It
Is
doesn't
it?
have to be free.
So dining is recreation in your interpretation?
It is.
Let's move on. You've asked him that many times. We need to get
Sidewalk
going.
adjacent to the project site is the location for an urban trail public art piece known as Grove's Vision. You counted that already, right? You counted the sidewalk already.
Yeah, but that sidewalk also has a public art component, which is part of an urban space amenity.
Are you going to count it twice?
I'm counting it as a feature that adds to the consideration of that area being substantially providing urban open space amenities.
The term is substantial open space, I believe. So does that add to the open space?
I think it's a special corner, and I think We don't have it in every corner. And actually, it might be in a bulb-out section of the street section there.
Well, and then your next bullet is cafe spaces along Battery Park Avenue and Page Avenue. You counted those already too, right?
But they're urban open space amenities, so we're making the point of how this area altogether with trees, benches, wider sidewalks, pedestrian crosswalks, wayfinding signage put in for the community, how that all fits into an urban open space type of designation.
You counted it already, yes or no?
I don't know what you're saying, Count, because I'm not coming up with a number. Are you? I'm not coming up with a number.
Well, I'm asking if you have. I mean, I asked you what substantial was. Are you counting that as
I think it's
substantial area?
It's meaningful area, absolutely.
Does it add to the substantiality of the area, meaning the area, the square footage of open space?
It adds to the usefulness of the area.
You counted it already as square footage, though,
I didn't count square footage.
okay? Street trees, wide pedestrian crossings, benches, surrounding landscape, you counted that already too, right?
Counted it or considered it? I think it.
It's duplicative of the bullet you already had, which dealt with the sidewalks.
I think it's illustrative of what an urban open space setting should have, and that's what our expectation is, which I think is what is provided in the project.
It's not adding to the area. You already took that into account.
It's not adding to additional area. Those are shared spaces, sure.
Okay. Then the height of the 8-story deck, which is a deck for hotel guests with rooms adjacent to it, you considered that open space too, didn't you?
I did.
That's land occupied by structures other than recreational structures. Is a hotel a recreational structure?
The deck is when it's adjacent to the room. A balcony is when it's adjacent to the room, is it? Is it not?
Wouldn't any developer just love to have you interpret the UDO this way for downtown, for now and in the
Please
future?
just ask him questions,
I
and let's
have-
move along.
I mean, you're setting a precedent here, Mr. Kleins. Is this a precedent you think should be set for the city?
In the downtown area, it's a special environment. The open space is not required to even be on the same site, which is unusual. Although this section, 711-4, is expecting it all to be provided on site.
But
In the downtown area, we have a special district where it doesn't have to do that. It can, but it doesn't have to in order to meet that standard. So this is why all these other things are important factors in considering valuable, useful urban open space in an urban environment. And that's the thing we've been trying to create in the downtown area, is that there's a viable urban space that has spaces up above and below.
would you like to answer my question, please?
In the downtown master plan, they talk about Vista Parks. How do we get more Vista Parks? It's a goal in the master plan. This is kind of how we do it, because we're going into the direction of rooftop decks. It's a great thing. It adds to recreational use.
Mr. Glines, you gave this developer a 25% bonus for the open space that you consider to be substantial. Is that a precedent that is being set with this hearing?
I think each case.
Let me just interject. He is not, you were at this hearing to ask this council to give that bonus. He
That's
is
true.
not giving the bonus.
I withdraw that question. You have another bullet that is your last one that says, by definition, the floor plate requirement of the hotel tower above 75 feet is limited to 50% of the lot area under your determination. Then the other negative space is the same area, is open and not built upon above that level. Well, it is built upon, correct? It would be built upon.
Not above the level of 75 feet.
Okay, but it's not open space because it is land other than recreational structures. I mean, it's not open space
Because
because...
it's an area of a void, it's a void
Of a
space.
building.
That supplies, what happens with that space, the gap. There's a gap. Mr. Fraga is designing a gap at the podium height, and that gap, open space, means area intended to provide the light and air. What else would that purpose be for? You can't occupy it, but you can enjoy it, because it allows a scenic quality.
It does not meet the
Airplane.
definition of open space in the UDO, correct?
I believe it could.
The entire 50% that is not the tower is now
It's an item of consideration.
it's a structure. Can you let me
Yes,
finish my question?
All right. Let's question and answer, and let's
That's
wrap
okay.
it up, because you've asked him the same thing many times. Let's just get it
I'm getting
get
to
it
the
done.
last bullet
All right,
point that
thank you.
he has presented to you for the first time at this council meeting. 7-11-4 says that you, in no case shall structures other than recreational structures be used as open space. This 50% that you're counting again for the FERC property is a structure other than a recreational structure, correct?
It's above areas. It's above areas that will be used in ways that have a recreation component to them. They're balconies and decks.
So you're going to count that again? You've already counted the balconies and decks and
I'm only
the
making a point here. I'm not counting again.
Okay. I mean, you got all these bullet points, but really, you're counting the tops of buildings and sidewalks, correct?
Yeah.
And one thing that I want to clarify, too, is the approval from the Planning and Zoning Commission, your staff report, and the staff report, I think for the City Council, says that there was a traffic study done for traffic on Battery Park, on Page Avenue. That traffic study was not in your file. Have you reviewed one?
I personally have not reviewed one, and I'll have to look at that note to confirm. We could make sure that's...
And one final thing, this
If I might just say, the traffic studies are reviewed by the Transportation Department, city engineer, traffic engineer.
okay. Now, this shadow study that was done, that you referred to, you didn't present that today, did you?
I did not.
And it only arrived in your office May the 6th, correct?
I don't remember the date, but I could accept that is possibly May 6th. I don't remember when it came in.
And you didn't review it to determine whether it was a valid study, did you?
I did review it to determine whether it was a valid study.
And how did you do that?
I reviewed the incremental images based on point-in-time information provided with the images.
I think that probably, Mr. McGuire, is that going to be presented by in your presentation?
Although it really hasn't been made an issue.
Well,
And I'll just withdraw that question, except for what you're saying is you just reviewed the images they provided to you, correct?
Correct.
Okay. That's all I had.
Okay, Mr. McGuire, do you have some questions for Mr. Glines?
If I may.
Oh,
You
hold
say
on.
we can interject a question?
Oh, anytime. Go ahead.
Just, it's a quick one, but Mr. Glines, according to the presentation we heard, the proposed square footage of the tower, if those numbers were correct, they represent 55% of the surveyed area. Were those numbers on the plans correct?
We identified early in the staff report that there was a corner parcel that was not originally included in the survey, and it wasn't registered by Buncombe County.
Right. Okay, so the later survey was right.
Yes.
But even with the later survey, according to the building plan we were shown, the plate, or whatever you call it, of the tower represented 55% of the 20,031.
I don't think so. I think it's 50%.
Right at 50%?
Yes, just below 50%.
Okay. Thank you.
My understanding. Thank you.
Okay, any other council members? Okay.
Mr. Glines, did your answer just now explain why?
Remember to talk in the mic.
Thank you. Mr. Glines, did your answer just explain why there's no question about this project being under subsection C rather than B?
Yes.
And by the way, you said you were a park planner for a number of years?
Yes.
On a day when we're celebrating Pritchard Park, who designed the current Pritchard Park?
I had a lot to do with that.
Okay, thank you. Now, in terms of the open space, you were asked if you've considered open space above a building. Have you had any building like the Grove Arcade where there was a permanent easement allowing nothing to be built above that airspace?
I can't think of another example.
And is that important, that if you could consider open space above a building if the airspace is permanently protected?
I think it's substantial information and quite an unusual situation, correct?
Now, you've actually, you're talking about giving a bonus to Mr. Fraga. You approached this on behalf of the city,
Yes.
and in fact, you've added requirements to this project, I believe, having to do with the south side setback.
Yes.
And you've changed the project because you thought it needed to be done so with the UDO.
That's correct.
But now, with those changes that have been made, you say this project fully complies with the UDO.
Yes.
The question, I think it's beyond cross, it's friendly cross, and it's legal.
Well, you asked him a lot of questions about whether it complied with the UDO or whether it didn't, so I think he can follow up with that. But you know, if you want to call him as a witness, I think you can do that as well, but we might as well, I think, do you want to use him as a substantive witness as well?
No.
Okay.
Can you please put that standard up so we can see it again?
The definition, I believe, or the
Yes,
standard for the,
This screen, exactly.
oh, I'm sorry.
You just have to the right. Okay.
Oh, Maggie, can you help with that? Thank you.
Okay. Now, you heard Mr. Davis say that within a ordinance or a law, the same phrase can mean something different in different places.
Right.
Is that true of open space standards?
I think so in this case. It is.
And in fact,
We're recording.
okay, in fact, this standard is more restrictive because it relates to actually designating something as open space. Is that correct?
Correct.
Whereas the standard of open space for purposes of this project, it doesn't have to be designated, it just has to be considered.
That's correct.
So would you apply this more restrictive standard for an open space designation to the project at issue?
No.
Okay. And you say that the patio or deck on the side of this project would be used for recreational purposes?
I feel that that's recreational purposes.
And you feel that dining out is a recreational purpose?
I think it is, especially in downtown Asheville.
And if you put aside, completely put aside the Grove Arcade in the top of that space that is permanently dedicated to be open, if you put that aside, do you still think there's sufficient open space?
I think that, yes, and I think that most areas of downtown would love to have the sidewalk configurations and opportunities for the streetscape that we have at the Grove Arcade and surrounding areas. We're working towards that. That's really a model. That's really a model for the downtown, is to have the wider sidewalks. We're working on it all the time. Every project we get, we try to assure that we're getting minimal, but trying to get more. So I think it's a model for downtown.
And so taking out the top of the Grove Arcade, which was one of the 9 examples of open space, the other 8 are sufficient, you feel, to look at this and make that consideration and approve the
do.
project? Thank you.
Question?
Me too.
Mr. Glines, on the issue of permanence of open space, came up earlier that an easement might be changed. There are different ways that open space can be created by ordinance, regulation, law, granting of property rights through an easement. Are there any of those that are absolutely permanent? Can any open space be converted to?
Other uses, maybe. I guess our most permanent ones would be the street right-of-way.
But we
And-
close streets.
And we
This
do, and
pencil all the
we
time.
change. And obviously, in this design, in the 1990s, we had more pavement, and we converted it to the configuration it is today to increase sidewalk space. That's fairly common. We did that also, if I might make a reference to Pritchard Park. If you remember the sidewalk along College Street, back in the old days, that was a 9-foot sidewalk, and we basically doubled that to 17 feet to increase the open space and the usability and the enjoyment of that space. So that's a goal we're trying to do, and I think it's an example here. Yeah.
And this section regarding open space, in contrast to 7-2-5, 7-2-5 uses the term, but not limited to it. It provides some guidance, but it says, here are examples of open space, but open space is not limited to these things that follow. We might want to put that back up there to
I think I can
see.
find that. I have it in my staff report. I did include, I believe it's,
Could you read that out loud?
okay. Open space means an area that is intended to provide light and air and is designed for either environmental, scenic, or recreation purposes. Open space may include, but is not limited to, lawns, decorative planting, walkways, active and passive recreation areas, playground, fountains, swimming pools, wooded areas, and water courses. Open space shall not be deemed to include driveways, parking lots, or other services designed or intended for vehicular travel.
And just throw the other one back up. So this uses that, but is not limited to phrase. And the application of this is for the purpose of, help me with this, defining open space in the context of
It's in the context of, the unique context of downtown. Because downtown is not required, in my opinion, required to provide on-site open space. It can. The tests we were making with the C for larger floor plates was surrounded by substantial public or private. So I think that this is helpful from looking at the general expression of open space and in the intent in downtown, based on even reading the downtown master plan, was that the purpose of all those extra regulations, which were extra with the downtown master plan to restrict development in the downtown area, was to make sure we had plenty of areas that weren't built upon above 75 feet. So, and the street wall has the same purpose. It even states it in the purpose of street walls, setting that in. It's to make sure there's air and light for the people on the ground and also the people next door. So I think that my sense was, and after working on the master plan, was that that's the intent. We understand we're going to tell developers or property owners downtown that you can't build on your whole site. You're going to have to start squeezing things in at certain points. And the trade-off is this 50% opportunity. It's for open space that can be found to surround the property, to be part of the property. And I think in this case it was met. And we weren't trying to give something away or all that. We're just trying to make a reasonable development and interpret this area of the UDO in a reasonable fashion at this context. Now, would everybody else in downtown, every other property, meet this standard? I don't know. We have to study it on a case-by-case basis, and that's what we have here. We have a site plan. That's what we did. Okay. That's helpful.
Can I return to the question I asked before? Just because I've run the numbers again. According to the plan that we're given here, this is the floor plan for the tower. Using the dimensions on the plan, I come up with 11,000 plus square feet. In other places, it says 10,015, which would be 50% of the 20,000.
Yeah.
What's right?
Which is it?
What's the real number? If it is 50%, it seems to me it complies. If it's 55%, which is what the plan seems to indicate.
Information provided by the professionals who sealed the drawings, the architects, is the 10,000, not the 11,000 number.
Then the dimensions on the plan are wrong. On the plan, it's one of the,
Hey,
sorry.
what exhibit do you have there?
5.
So that was submitted by Mr. Davis.
but it is the same formal plans we have in our
Okay.
packet
Okay.
here.
Well,
I'm
what-
just-
For the record, Exhibit 5.
Okay.
Okay, Exhibit 5, yeah. Coupled with the other, anyway, that's all, I'm trying to get at the number there. What's the number that's accurate? The 10,015, it appears to me, is just 50%. But that doesn't correlate to the dimensions shown on the plan.
I wonder if that's something that maybe the architects could.
Is the architect here and sworn in? Do you want to address that question?
Can we let them do that on their case?
Well, I think if there's a sworn-in witness that a member has a question for, that they can come and answer it, instead of having Alan trying to figure it out. I'm not saying he's testifying, let him just answer the question if he can.
The question is, you're looking at the overall dimensions and you're not considering the undulations of the floor plan. So there are some cutouts in that overall. So if
I
you
see,
took,
so you don't just take the rectangle?
no, because that wouldn't be the floor plate. That would be,
Okay.
I don't know what that would be.
I see what you're saying. Okay.
But for the purposes of...
It's a jigsaw puzzle.
Yeah,
It's-
for the purposes of code and the way we calculate square footage.
Thank you. You totally clarified it for me.
Okay. Anything else for Mr. Glines?
I have just, so, Mr. Glines, are you saying that when you were looking at open space, in evaluating substantial open space, you were looking at the definition in 725 and not 711.4, and that would be consistent with what you have considered in the past with downtown properties?
Right. In general, in downtown, we don't have an open space requirement in any other case. So this is a fairly new standard in 2010, but correct, yes. For downtown projects, this is where I'd look.
Okay.
Regarding open space also, you've said that the rooftop gardens or restaurants or whatever would be considered part of the open space, meeting the requirement there. Does open space need to be publicly accessible?
From the sidewalk level, no. But can the public go to this space? It's true, but it doesn't, that's not the test. It says public or private open space, so there's the assumption that you could have a private balcony or deck that no one else would be able to use, such as the hotel guest who has their own balcony for their own purpose. No one else can really visit their room unless they're a guest of the person, so it's not open to the public, but I think that would be okay.
So if somebody wanted to go to the rooftop restaurant but not spend money, that's considered part of the open space? And that, help me understand that.
No, that would be open space. I think that the master plan was trying to get at Vista Parks, and they talked about rooftop Vista Parks. They wanted to encourage this, so they used the term, and I would say that, and they did, in the code, that code did not give us a lot of direction on it's got to be free, but even if you go to the top of the Empire State Building, you're paying for it, so it's public, but you have a fee, and maybe a fee is service at a restaurant or a bar, I don't know. I know there's plenty of downtown buildings, including 21 Battery Park Avenue, that has a rooftop a facility up there for owners. And I would say the same for the Battery Park Apartments. There's a ballroom up there with private overlooks that are serve as open space for them and fantastic views, but you have to be a guest or you can't just, as the public, walk in. And I think that's normal in this consideration.
Thank you.
I suspect we might want to try to nail down, in the future, that's not today, but what substantial means. Because substantial is kind of loosey-goosey, I think. But I mean, that's for a future discussion.
Well, that's part of what you got to decide. You have to decide tonight. That's part of your discretionary decision based on the evidence.
May I ask one follow-up question?
Yes.
Mr. Glines, let's assume that this developer is entitled to use the rooftop of the Grove Arcade as open space as you proposed. And let's say the next developer wants to build a tower on the other side of the Grove Arcade, on the western side of it. Can they use the same open space, the same rooftop as open space?
I think we would study the context of that development.
Can you answer yes or no?
I think it would count.
It's hypothetical. Just let's finish up. You said one question. You're asking him to speculate.
He said yes, it would count. I thought I heard him say.
Okay.
It was on the west side, and they were developing on the west side, and they were surrounded on the other side.
Using the same open space.
The Grove Arcade is useful open space if you're on the west side or the east side, because the sun is going to reach your building.
The north side, the south side. You could totally surround the Grove Arcade with towers using your definition of open
Well,
space.
the north side's already got a tower, so I don't think.
South side.
South side's got a city building. Don't know if we have any plans for that. That might be something to put on our
Well, I
list.
mean, theoretically, you could do that under your definition of open space.
I think it's surrounded by.
Okay? That's all I have.
Okay. All
I
right.
do have a witness.
I need to ask a question. Mr. Glines, if there were a public park, a green, pristine public park on the side of the Grove Arcade, would it be the intent of the ordinance that that would qualify as open space for any buildings that surround it?
Yeah,
Okay.
that's right.
This would be a good time to break, perhaps.
Well, that's up to you.
Well, it seems that we're in a natural breaking.
Okay, all right. I mean, it's fine from a,
Yeah,
I mean, you have another witness, but we haven't started the examination, so I think that the council would like to take a break.
That's fine. I mean, I can make the witness relatively short, but it's up to you all.
How long is short? How short is short?
We're more than an hour past our normal break time.
Right.
Then you should take a break.
And Maggie, do we have a closed session that would fit in less than 20 minutes?
I believe Ms.
I think that we can make it work for you. I think if we can make that work, so is that what you're...
Great. Well, our
suggesting?
break will be 20 minutes, folks. But we will conduct a closed session during that 20 minutes. And
Only if you
if
agree with the
Councilwoman
motion.
Whistler would read the motion for closed session.
Or is it all?
No, just that one, that's the extra copy.
I move that the Asheville City Council go into,
Hold on one second. Let's move to just, suspend the hearing we're in and to move to take a break in the hearing we're in.
Yeah, let's move to suspend. Is that
Or,
pause?
that'll work.
Move to suspend the hearing that we're in and go into closed session.
Well, let's just move to suspend first.
Motion to suspend.
Okay.
To suspend. Second here. All those in favor of suspend?
aye.
Okay.
Opposed, none.
And we'll come back after our break and go back into this hearing.
And I move that the Asheville City Council go into closed session for the following reasons. One, to prevent disclosure of information that's privileged and confidential pursuant to the laws of North Carolina or not considered a public record within the meaning of Chapter 132 of the General Statutes. The law that makes the information privileged and confidential is NCGS 143-318.10.3. The statutory authorization is contained in NCGS 143-318.11A1. 2, to consult with an attorney employed by the city about matters with respect to which the attorney-client privilege between the city and its attorney must be preserved, including a lawsuit involving the following parties: Roger S. Alley, City of Asheville. The statutory authorization is contained in GS 143-318.11A3. And 3, to establish or to instruct the city staff or negotiating agents concerning the position to be taken by or on behalf of the city in negotiating the terms of a contract for the acquisition of real property by purchase, option, exchange, or lease. The statutory authorization is contained in NCGS 143-318.11A5.
Second.
All those in favor?
Aye.
Aye.
All right, we'll be...